Hello and welcome to today's episode of Legally Norette or Legally Raven-haired. We're still talking about civil procedure and we're going to be talking about it for quite some time. Okay, so I really have been going from the book, but the book doesn't start in order. That's the example and explanation book by John Glennon. So what we're actually going to do is we are going to what we want to do is we're actually going to read all the rules, okay, ourselves and make videos about each one. So this is rule one, which really just explains what civil procedure is. And then we will go, I believe there's 86, if I'm not mistaken. And I could be mistaken because I'm new at this. All right, so let's talk about the Federal Rules of Civil Procedure, Rule 1. What is it? So the Federal Rules of Civil Procedure govern civil proceedings in the United States District Courts. Their purpose is to secure the just, speedy, and inexpensive determination of every action and proceeding. Okay, the history. It was approved in late 1937 and it went into effect in, I believe it was January 3rd of 1938. It replaced the Federal Equity Rules and Conformity Act of 1934. So what was wrong with the Federal Equity Rules and Conformity Act of 1934? It was too restrictive. So the Conformity Act required that procedures in suits of law conform to state practice, usually the field code. Okay, so usually the field code or a pleading system that was based on common law. So common law pleading system is very formal, traditional. It requires particular phrases and requirements. So the omission of certain keywords would actually have a suit dismissed. So the FRCP is a notice pleading system. It's less formal. It was created and continues to be modified by legal experts. It's less technical than a common law pleading, and it focuses on a legally actionable claim. So you give notice of what your grievance is, you leave details for later in the case, and you concentrate on actual law rather than the exact construction of pleas. So even if your plea isn't constructed exactly right, your case can move forward because you're saving the details for later in the case. What was the field code? Well, the field code was adopted between 1848 and 1850, and it was an intermediate step between the common law and the modern rules we see today. It was created by a New York attorney, David Dudley Field, and it was partially inspired by the civil law systems in Europe and Louisiana. It merged law and equity proceedings. All right, so that was the field code. So the FRCP, does it apply to everything? Well, here's something it doesn't apply to, and this is multi-district litigations. So a special federal legal procedure designed to speed the process of handling complex cases. So these cases would be air disaster litigation, so a plane crash, or complex product liability suits. I'm thinking like the Toyota brake issue, not sure, I'll have to check into that. So when the statute was established in 1968, these cases were a really small minority. However, things have really changed. MDL have gradually become the dominant component of the U.S. federal caseload. JPML published statistical data that said by the end of 2018, 51.9 or basically 52% of all pending federal cases were centralized multi-district litigation, so more than half. This is an issue because the FRCP was set up to have a procedure for litigating civil cases. And here, this, which was previously minority now, which has a slight majority, is not following this procedure. So originally the MDL procedure was just a pre-trial management tool. Well, now it's moved toward alternative dispute resolution or mediation, and it has really set the table for global settlement. So that is rule one of the Federal Rules of Civil Procedure. Look for rule 2 video soon.